other things may come up in a child's life, that the priority be, of course there are situations that could occur where they're out of everyone's hands, but that if the parties themselves are in charge of scheduling these events, that the thing that comes first is contact and time sharing with the mother. So that's the clarification portion of our request. With regards to enforcement with regards to enforcement, specifically we were referring to the FaceTime/Skype issue. There was a motion for contempt hearing on December 21st, 2015. At that hearing, the court ultimately did not find Mr. Michaud in contempt, but did enforce the order and stated that all parties must abide by the June 13th, 2013 supplemental final judgment. And specifically, continued time sharing as in the order. The order allows for Skype and FaceTime. I think it specifically says Skype, but I think the parties have used FaceTime instead. However, if this court were to order Skype instead, I'm sure my client would make that happen. But we're asking that the court enforce the original supplemental final judgment as well as the December 21st order requiring that Ms. Casey get FaceTime. She testified today how important that is, being that she only gets to physically see her daughter 12 hours a month, that she testified there is a difference between a phone call and FaceTime, that seeing her daughter is important to her. And we're asking that that be reinstated, as it already was. It was reinstated in December. We're asking the court to enforce that order. With regards to the contempt, Your Honor, as I had stated earlier, if not the letter of the law, certainly the spirit. Mr. Michaud testified at the July portion of this hearing that he believed that Riley made a Mother's Day card, but he never bothered to ask her whether he should mail it. And since there was no May visitation, he guesses she never got it. I believe his actual testimony was, well, I think she said she wanted to give it to her. And since there was no May visitation, she never got it. His order, his time-sharing schedule, parenting plan and time-sharing schedule, actually, unlike most, specifically requires him to encourage the minor child's written communications with the mother, half-sister, stepfather, and other family members. Although the time-sharing order says and/or regarding Skype communications and telephone, we would argue that the father should not be the sole determinator of whether that can happen, that he should not be able to decide all on his own that mother will never have Skype when it is specifically in the time-sharing schedule, and that if Ms. Casey is going to be held to the letter of every single order, that Mr. Michaud should as well, and that if the time-sharing sets for 6 hours per day on Saturday and Sunday, he should not be able to schedule the child for things that are going to cause time-sharing to not be 6 hours on Saturday. That he doesn't get to decide that, well, then you'll have 4 hours on Saturday and 8 hours on Sunday. The order specifically states 6 hours on each day. And so in that respect, in the fact that he has completely denied all Skype or FaceTime, the fact that he has gone out of his way to make telephone conversations difficult, or the scheduling of them difficult, that he has made the scheduling of visitation difficult, we would argue that he is in fact in contempt.
Response?
Yes, thank you.
Sure.
First of all, I think the court should limit your consideration of this case to what was pled and not go beyond what was pled in this motion. The Paul versus Johnson case, which I provided to the court, says that in order to hold my client in contempt, the language of the order must be clear and precise, and the behavior of the person must clearly violate the order. Similarly, the language in the Rovo versus Rovo case finds that the order giving rise to contempt proceedings must be one that clearly and definitely makes the person aware of its demand. The trial court must find the person's ability to comply with the court order, and when the trial court imposes a coercive fine, the court must consider the fine will be for financial resources of the court. There's been no evidence of anything that. We've got an order that was drafted and a parenting plan that was drafted before the lawyers sitting before you were involved in the case that says that it's telephone and or Skype communication. My client can't be in violation of a clear and direct command to the court when it's clearly left that in a nebulous fashion whether how the communication occurs. The spirit of an order, clearly under the Johnson case, is not something that someone can be found in contempt of. So I would suggest to the court that there hasn't been any evidence that these telephone contacts didn't take place. There hasn't been any evidence other than a May visit that the former wife conflicted herself out of, that she hasn't had her time with this child. She was offered time after the track meet and declined. So again, I would suggest to the court that there's no finding, or should not be any finding in contempt. As far as the clarification issue goes, Judge, there's a petition for modification that has been pending in this case for a very long time. The clarification they're really asking for is for the court to modify the previous orders of this very, very litigated case. I mean, if you want to go back and look at the history of this case, I'd suggest you look at a few orders, and let me give you some dates. There's an order entered on April 27th, 2012, indicating in paragraph 2 of that order that the wife had failed to provide therapy records at that time. On April 27th of 2012, there was also an order entering a temporary restraining order prohibiting any direct contact going to the school and the home. Again, an order entered against the wife. The history of this case is extremely well documented in great detail on the June 19, 2013 amended supplemental final judgment. I think in no fewer than 8 separate paragraphs, the former wife was found in contempt for violation of previous orders of the court, where she directly violated those orders. The parenting plan that's attached, and I gave you a copy of, was attached to Exhibit C, again, specifically has requirements that the former wife is supposed to comply with in order to expand or even continue her supervised visitation. I think that's clear she hasn't complied with that. There's nothing in those orders that requires my client to do anything other than what he has been doing. I think it's apparent from the wife's demeanor and her testimony on the stand that if anyone is in contemptuous disregard of these court's previous orders, it's the former wife. She is unable to acknowledge that the position that she finds herself in is a result of her behaviors and her actions. The court's order that was entered by Judge Ryman makes findings concerning the wife's continuous contemptuous behavior towards the court, paragraphs 1, 2, 3, 4, 5, 6, 7, and 8 of that order. Counsel's relying upon the court's determination that the former wife shall continue her contact with the minor child as previously ordered in the amended supplemental final judgment. But all other relief, all of the other findings in that order entered by Judge Ryman on January 8, 2016, could be in no way read as favorable to the former wife in this case. Judge, I would request that the motion that has been filed in this case be denied, and the court simply be direct the parties to continue to comply with the previously entered orders.
What else?
Your Honor, my only response to that would be solely that petitioner's position is Ms. Casey has been found in contempt over and over and over again, and therefore my client should never be found in contempt. That is the argument that he's making. Ultimately, we're not here on a motion for contempt against Ms. Casey. We're here on a motion for contempt enforcement and clarification. I don't believe in any way that the clarification that we're seeking is a modification, although I agree that there is a pending petition for modification on both sides. And that those issues will be addressed at a hearing on those petitions. Today we are not here on any of that. Today we are here on the motion that is before the court on a motion for contempt enforcement and clarification, and we are seeking the same.
As the parties know, I was not the judge on the case much prior to today. There is a whole body of rulings that are made by other judges, right or wrong, with or without evidence and support. They are what they are until and unless they're changed, whether it's by supplemental or something else. Those orders and the findings are all there and part of what I have to factor into any ruling that I make. I certainly have no independent knowledge and was not present at the hearings to know the basis for all of it. So I'm not really re-looking at that issue today. Parties have filed supplemental petitions that are more appropriate for making changes to any of these prior rulings or treatment or conditions or supervision or schedule. So I'm going to tell you the ruling, and then when I've done that, I just want to spend a couple minutes to converse. But I did need to start out with the fact that all I'm looking at is specific conduct described in the motion for contempt, or enforcement, or clarification. As far as the motion for contempt and enforcement, I have to find first that there's a violation of the terms of the orders by the petitioner, the father. And if I do, then I have to go to the next step and determine whether it's of a contemptuous nature. And I can't find either. There are valid legal reasons for certain of the contact to not occur, to occur late, or the communications to occur late or not occur exactly as provided in the order. And while things could have been done differently by both parties, I cannot find a violation of the court's orders, so therefore there's nothing to enforce and no contempt. I want to talk about one issue of clarification, but this is the main focus on the contempt and enforcement. It is a valid question raised by Mom that is not appropriate, certainly for me to answer, and that is a priority, because the order is what the order says. It's not been violated. But I just want to comment on that, a couple of things, because other than the supplemental and trying to change some of the meat and substance of the prior orders, I'd really like to do what I can do to make it work in the meantime. And the question of priority is a bit of a problem, and it creates problems in and of itself, and that is this. Of course, contact with the parents takes priority over almost everything. But for the life of me, I can't figure out why she just didn't go to the event. She's apparently being told ahead of time where and when. And the problem that these prior orders are creating difficulty is it's easy with a 5 or 6 or 7 year old, but with a 13-year-old, it's just not that easy anymore. You know, an adult trying to keep a 13-year-old on the phone for more than a minute and a half is very difficult. I have no evidence that the father had anything to do with causing that communication to terminate quickly. The other complication is the fact that she has supervised visitation, which makes it difficult to work around. And just generally, we've already mentioned it, and the fact that she's living out of town, was relocated to North Carolina or South Carolina? South Carolina, which logistically creates problems. And as we already mentioned, the age of the child. So if you get 6 hours a day on a Saturday and Sunday, why don't you do the 6 hours going over to Tampa? I realize the distance and all that other stuff, but if there's a soccer game or something else, it's your choices not to do it. The matter of clarification is to figure out, and I'm not sure it's a whole lot of help, but to figure out the intent of the order and in essence put the time sharing back to where it was. It doesn't specifically mention the order concerning Skype and or telephone. It is my interpretation that it means to reinstate the Skype and or telephone as well. The reason why it doesn't add a whole lot is Skype or telephone would be compliance with the order telling us it's changed in a supplemental. So bottom line is while there are issues in decisions by both parties that I wish were being made a little different, there is no violation of the orders that I find. There's nothing to clarify except I clarified the Skype and or telephone. That part is reinstated as well. Beyond that, the motion orders are denied, and Mr. Peters will do the order. The thing I want to talk about is I don't have a lot of history with the case, so I am going to presume that mom and dad both are proceeding in good faith, that you're proceeding in good faith at this time, trying to get contact with the child. You're hanging on by a thread to the little bit of contact you have. I don't think you made a good judgment call in turning down time, and I've kind of hit him over the head that if it's your 6 hours on a Saturday, you have the right to go to the event. You got to coordinate it with the other person. But I'd really like to see, I mean, I didn't write the order. It says telephone and or Skype. Really like to see Skype contact. Really like to have it. And I will tell you what Mr. Peters knows this, Ms. Jacobs knows this, but I'll tell you too. For future, I know there's history, but what you all do in coordination and cooperation with the other, and I'll jump on Skype, is a big deal to what happens later. The more you all will respect the parental rights and contact of the child with the other parent, covering safety issues, which are covered in the orders, the more positive it'll go for you. If you're acting reasonably, and I'll jump on Skype, if you're acting reasonably, you're going to be looked in a great deal more favor when 6 months down the road you all get to a trial on the supplement. Okay. Anything else at this point, guys?
No, Judge.
Anything else?
No, Your Honor.
Okay, we'll be adjourned. Mr. Peters will do the order for us.
Yes, sir. All right.
Thank you. And let me check. Anybody have any of the evidence?
No.
I do not.
I have 4, 3, 1, and 2, and then I think that's it, right? That's all the evidence?
I believe it was just 1 through 4.
1 through 4. That's what I have. Okay, thank you all.